I'm Ben Meiselas from the MeidasTouch Network. The Colorado Supreme Court heard oral argument earlier in the day on the disqualification case under the 14th Amendment, Section 3 regarding Donald Trump. You will recall that the trial court, after a lengthy trial, found that yes, Donald Trump engaged in an insurrection, but that he could not be disqualified under the 14th Amendment, Section 3, because the trial court held that Donald Trump was not an officer, as the term is used in the 14th Amendment, Section 3, and thus the section didn't apply to him, even though he engaged in an insurrection. Now, the oral argument was a pretty shocking thing to watch. I'm going to show you a clip from it right now where Donald Trump's lawyer, Scott Gessler, who used to be the Secretary of State in Colorado, actually argued that the Confederate President Jefferson Davis would be able to run for president and that the Democratic Party could conceivably nominate President Obama for a third term. In other words, what Scott Gessler argued on behalf of Donald Trump is that because Trump is not an officer, as the term is used in the United States Constitution, in essence, Donald Trump is impervious to the restraints of the Constitution and the limitations imposed on people seeking the presidency. Let me show you that clip right now, and then let's talk about it. This is Donald Trump's lawyer, Scott Gessler, before the Colorado Supreme Court. Play the clip.
If the entire nation chooses someone to be president, can that be an insurrection, or is that democratic choice? Remember, the president is a little bit different. Everyone in the country has an opportunity, or should have an opportunity to vote for that person.
Go ahead.
I don't think anyone here is suggesting, and I don't take the petitioners to have been arguing that the election of a person as president is an insurrection. I think that what the insurrection might have been is a different question. So I'm not sure where you're going with that argument.
I'm going with the broader context of the president is different, and if everyone in the country chooses a particular person as a president.
So if everyone chose an insurrectionist, Jefferson Davis, let's use that example. If Jefferson Davis ran a while ago, and the electors who were not themselves insurrectionists chose to put him into the presidency, that would be fine under Section 3, and that would be consistent with the purposes of Section 3.
That would be the rule of democracy in work.
But the rule of democracy, there are limits. I mean, the president can't be under 35 or can't be, someone who wasn't born in this country. So you could, the argument, if you take your argument to the limit, it would say we can elect Governor Schwarzenegger or, my 27-year-old kid.
I don't think it goes that far. It's that rule embodied in the text of Section 3. Now, there are plenty of anti-majoritarian measures in the structural constitution, and there are these qualifications. No one argues that. But when we're interpreting Section 3 of the 14th Amendment, and we look at the history behind that and the context and the language they used to satisfy the conditions of Section 3, you have to be an office under the United States. You have to hold the office under the United States, and you have to be an officer under the United States, and you have to take an oath. You have to have all four of those items in place. Any one of them, Section 3 does not apply.
Stepping away from Article 3, though, for a second, and sticking with the Constitution, could the Democratic Party put President Obama up on the primary ballot? Could that happen?
I haven't done a full analysis of that particular provision, Your Honor. I'm really sort of focused more on Section 3, but could they do it? Conceivably, I think it's an open question. If you look at the political question analysis of the Article 2 courts, the weight of authority was that states could not prevent that.
If I understand your democratic process argument, that would seem to be the logical conclusion. I'm just trying to make sure I understand the breadth.
The breadth is confined to Section 3, Your Honor.
But stepping away, because you were focused also on the Constitution.
Look, I'm focused on the structural Constitution to look at the language. The officer of the United States is used 4 times in the structural Constitution, and each time it does not apply to the U.S. president.
Go ahead.
I mean, not once does it apply.
No, I know. You didn't answer my question, but that's okay. I'm not going to. I want to let you use your time the way you want to use your time.
So I feel like
Please feel free to take another run at me, Your Honor. I do want to be responsive. Yes, sir.
I feel like we're going in circles to some extent right now.
And then Donald Trump's lawyer, Scott Gessler, argued that he's just making everything up and that everybody's just making things up. And this is all make-believe. I'm not joking with you. Donald Trump's lawyer argued to the Supreme Court of Colorado, Mr. Gessler, you're making it up, you're going to say to me. Well, so did the judge. We're all sort of making this all up. No, there's law. There's what's called the United States Constitution. Here, play this clip.
Why don't you focus, because your time is limited, on the one the district court adopted? And any public use of force or threat of force by a group of people to hinder or prevent the execution of the Constitution. What's wrong with that definition?
Way too broad. I think the petitioners actually admitted that a group of people threatening a mailman and preventing him or her from executing their constitutional duties, because that's one of the constitutional powers that Congress has, would constitute an insurrection.
What if we narrowed it to say prevent the peaceful transfer of power of the United States government? Would that be an insurrection?
To prevent the peaceful transfer? I don't think so, and I'm not sure, Your Honor. Look, I mean, if you look at historically in the context of how insurrection was used, I mean, it has to be for a substantial duration, not 3 hours. There has to be some geographical scope. There has to be a goal of nullifying all governmental authority in an area.
I guess I'm not sure where you said it has to be, where the temporal provision, where is all that coming from? I mean, Webster's Third New International Dictionary defines it as an act or instance of revolting against civil authority or against an established government. So you've added a whole lot of conditions there. I'm not sure where it came from.
I would urge you, I think probably the best exposition of that was the State Attorney General's briefs and the authority that they provided. Okay, but I think also if you look at sort of the historical record. Now you're going to tell me, Mr. Gessler, you're making it up. And I'm going to say, well, so did the judge. And I'll say, we're all sort of making it up at the end of the day.
Well,
yes, sir.
I just want to jump in on this point of how I don't know that we have to come up with a test that's going to necessarily address all circumstances. I guess the question, at least as to insurrection, setting apart whether President Trump engaged in insurrection, but as to insurrection, why isn't it enough that a violent mob breached the Capitol when Congress was performing a core constitutional function? In some ways, that seems like a poster child for insurrection. Why is that not true?
Well, I think what you're sort of saying is the famous quote. I don't know a definition of it, but I know it when I see it. That we don't have a workable standard, but we think in this instance it doesn't feel good, and it just seems
well. It's more than it doesn't feel good. For purposes of this case, what we need to do is figure out whether what happened on January 6th. One of the things we need to do is figure out whether what happened on January 6th constituted an insurrection. We don't need to come up with a definition for all times and all circumstances.
I mean, as you watch that clip, as you watch the other clip, I mean, the conduct here is absolutely atrocious. Now, the Colorado Supreme Court is a 7-justice panel right there. All of the justices in the Colorado Supreme Court were appointed by Democratic governors. They all serve set terms there in the Colorado Supreme Court. Donald Trump's lawyer, Scott Gessler's argument there mirrors what Donald Trump argued in his briefing. Here it is as well, and arguing that Donald Trump is not an officer, thus the court shouldn't even have jurisdiction over a 14th Amendment Section 3 disqualification case, and also arguing, and you heard Donald Trump's lawyer argue there, that Donald Trump did not even take the oath of office. And here you see the argument in written form. Summary of the argument. Donald Trump's lawyers argue the framers excluded the office of the president from Section 3 purposefully. Section 3 does not apply because the presidency is not an office, quote, under the United States. The president is not a, quote, officer of the United States, and Donald Trump did not take an oath to support the Constitution of the United States. And therefore, Donald Trump's lawyer argues that the 14th Amendment, Section 3, does not apply and the court does not have jurisdiction. Now, if you take a look at the 14th Amendment, Section 3, we'll pull it up right here. It says, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same or given aid, comfort to the enemies thereof. But Congress may vote by 2/3 of each house to remove such disability. And so the ultimate ruling by the trial court is that Section 3 says senator or representative, elector. It talks about state legislature, judicial officer, but according to the trial court and Trump's argument, it doesn't mention officer. But if you look at Section 3, it says, or hold any office, and it's the office of the presidency. So it makes no sense, and the president does take an oath of office. But here, Trump's lawyers arguing there is no oath of office pursuant to Section 3 of the 14th Amendment that Donald Trump takes. And as you heard the argument there, literally Confederates can become the president of the United States. Obama can seek another term, and the rules don't apply. It's what is so dangerous there as well. The lawyers for the petitioners here who filed this appeal after losing in the trial court went through a structural, textual, and historical analysis and basically argued again to the Supreme Court here as they did to the trial court. The reason that there's no specific mention of the presidency or vice presidency in Section 3 is actually well documented in the historical text. The catch-all, as it was believed when this section was drafted, was the or hold any office, civil or military, under the United States. That was a catch-all. And so the terms presidency and vice presidency were not removed because the 14th Amendment, Section 3, doesn't apply to them. It just, for drafting purposes, was viewed as being embodied in this kind of catch-all that was incorporated here, and it would also defy any common sense analysis or historical understanding that someone running for the presidency would be treated like a king and could engage in insurrection and attempt to overthrow the Constitution, yet can seek safe harbor in the immunities and seek safe harbor in destroying the Constitution, and that the Constitution would not apply to them. It simply is belied by all logic there. So the next question is what will the Colorado Supreme Court do with this? They will obviously be issuing a written order soon. And will they find that the disqualification clause applies to Donald Trump? And if it does, will that then go to the United States Supreme Court? But I wanted you, to hear the argument being made by Donald Trump's lawyer, Scott Gessler. And I want you to see the summary of Trump's argument saying that Donald Trump did not take an oath to, quote, support the Constitution of the United States. And you saw Donald Trump's lawyer trying to argue that in court. Let's leave no doubt about what the argument is that Trump is making and how dangerous of an argument that is. I'm Ben Meiselas. This is the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.meidastouch.com. That's store.meidastouch.com.